Okay, so we have some news with the ATF pistol brace rule and some of the lawsuits and some new things that have developed that we need to talk about. So let's break down what is now happening with pistol braces. Now, really quick before we jump into this video, I want to ask you all for a huge favor. Looking at some of my analytics, about 60% of all the viewers, even maybe just you watching this video and this channel, are not subscribed to the channel. So if you want to support this channel for free, if you want this type of two-way content to get out to more people, please consider subscribing to the channel. Of course, no one's forcing you to do it. If you want to support the channel, it's one of the free ways you can do that. And then also just double check that you're still subscribed to the channel, because YouTube loves to unsubscribe people. But regardless, thank you all so much for all of your support. Now, like I mentioned in the intro, in this video, we got to talk about what is going on with the ATF pistol brace cases and some of the things that have now developed, because a lot has changed and something new was just filed in all these lawsuits that is going to impact how this issue proceeds forward. The ATF recently has been suffering a ton of losses. In fact, they've suffered multiple losses in various cases, including the Cargill bump stock case. The Supreme Court recently issued a 6-3 decision in that case. And then the ATF also lost at the lower court level when it came to the whole engaged in business rule. A preliminary injunction was issued against that rule. And then also recently, you may recall that we did a video on a recent vacatur of the entire pistol brace rule, and that was a final merits decision that was issued by the lower court judge, Judge Reed O'Connor. However, some of the plaintiffs in the pistol brace lawsuits are trying to take this opportunity to expand on the lower court win that they received, that final merits decision, which struck down the entire rule. One of the plaintiffs has filed a 28J supplemental letter, which is essentially a letter that you submit to a panel saying that a new decision has come out that is going to impact this lawsuit. The Fifth Circuit three-judge panel in this case was set to hear the arguments on the preliminary injunctions in not only the Mock v. Garland pistol brace lawsuit, but a ton of other ones as well. So there were some oral arguments and hearings that were set for August, but the plaintiffs here are saying those reviews are essentially moot now because the lower court has issued a final merits decision which overrides what is now going on at the Fifth Circuit level. I know that might be a little confusing, but essentially the review that was set to take place in August deals with just preliminary injunctions. But the plaintiffs here are saying we don't even need to do that anymore. We don't need to have those hearings because we have a final merits decision. And unless the ATF decide to appeal and seek review of that final merits decision, all of these issues are moot and this case should be done. And you may say, well, no doubt they're going to appeal that. But like we just illustrated, the ATF has suffered losses in the Supreme Court, at the Fifth Circuit en banc panel level, at the three-judge panel already in the mock case in the Fifth Circuit. So the ATF has a very hard decision going forward. They can abandon this case, decide to just take their loss, go back to the drawing board, maybe try to promulgate a new rule when it comes to pistol braces, or they can roll the dice once again and seek a review from the three-judge panel in the Fifth Circuit of the final merits decision. Now, like I mentioned, the Fifth Circuit Court of Appeals decided to consolidate all the preliminary injunction reviews, consolidate all the cases that dealt with preliminary injunctions, and they were set to review and hear that issue in August. But in the meantime, the lower court, Judge O'Connor, was moving the mock case towards a final merits decision. There were cross motions for summary judgment that were filed. Essentially, each side, the ATF said, hey, Judge O'Connor, we should win this case right here and now without going to a full case, instead of going to a full hearing. And then also the plaintiffs, Mock and FBC, were saying the same thing. And ultimately what ended up happening is our side won. Judge O'Connor issued a final merits decision striking down the rule completely. And again, a merits decision which ended that case completely at the lower court level. In his ruling, Judge O'Connor stated that at the conclusion of the majority's careful analysis, they held that the final rule is properly characterized as a legislative rule. And it is relatively straightforward that the final rule was not a logical outgrowth of the proposed rule. Therefore, the final rule must be set aside as unlawful or otherwise remanded for appropriate remediation. So what essentially happened in front of Judge O'Connor is he issued a motion for summary judgment in favor of our side. And essentially what he said is that when the ATF created their final rule on pistol braces, they deviated too far from the proposed rule. You may recall that when the ATF first put forward the proposed rule, they had a worksheet, the worksheet 4999, which had a bunch of characteristic kind of checks where you would have to have this point system and you would identify certain characteristics on your firearm. You would check them off, you would add points, and if you accumulated enough points on that report card, well, then the ATF would say that specific firearm in that configuration was an SBR, and therefore it was subject to the NFA's requirements. With the proposed rule, they had that worksheet, but then when they issued the final rule, they completely scrapped the worksheet and they went to a more just vague and broad subjective standard. And what Judge O'Connor said in his decision is, under the logical outgrowth test, the ATF deviated too far from the proposed rule to the final rule, and therefore the entire rule is invalid and therefore was thrown out. Now, of course, that's a huge win, which struck down the entire brace rule, and that was a final merits decision. That decision essentially overrides the preliminary injunctions in importance. Now, as of right now, the ATF has not appealed. They have 90 days and essentially until, I believe, September 11th of this year to file their appeal of that final merits decision. So they still have time to file that appeal, but we haven't seen anything issued right now. They haven't filed anything, and that's because they've been suffering a ton of other losses right after they lost the pistol brace case. We saw recently they lost a 6-3 decision at the Supreme Court level with the bump stock case, the Cargill case, and then they lost the engaged in business decision, and then a bunch of other things as well. So the ATF has a very hard choice right now going forward. But the plaintiffs essentially are not waiting for the ATF to make their move or to make up their mind. Instead, they have filed a supplemental letter notifying the 3-judge panel of the merits decision of Judge O'Connor. The letter states that pursuant to Rule 28J, plaintiffs' appellees file this letter to inform the court of the district court's June 13th, 2024 memorandum opinion and order granting summary judgment in plaintiff's favor and its entry of final judgment attached to Exhibit A and Exhibit B. The district court held that the final rule violated the Administrative Procedures Act's procedural requirements because it was 1, not a logical outgrowth of the proposed rule, and 2, arbitrary and capricious. The district court entered judgment vacating the final rule. As a result, this preliminary injunction appeal is moot. And then they quote a precedent where generally in an appeal from the grant of a preliminary injunction becomes moot when the trial court enters a permanent injunction because the former merges into the latter. So essentially what the plaintiffs are saying is unless the ATF decides to roll the dice once again at the Fifth Circuit level, this issue is done and the pistol brace rule is dead. So now the ball is completely in the ATF's court on what they want to do. But with the recent Cargill decision where the bump stock rule was struck down, with the recent Loper Bright Enterprises Chevron deference case, the pending Vanderstock decision, which is set for review during the Supreme Court's next term, which deals with the whole, unfinished frames and receivers rule, review of 80%ers and the ATF's restrictions on 80%ers. That's set to be decided by the Supreme Court next term. All of that is impacting this case in the ATF's current strategy. They don't have a lot of options. They're losing at every single level when it comes to their rules, which I don't feel bad for them at all. So right now, their attorneys are probably scrambling to figure out what they actually want to do. Now, you may be asking, okay, where does this leave us all right now? Where this leaves us right now in this moment of you watching this video is that the pistol brace rule still has no impact on pretty much everyone nationwide. Not only do we have multiple limited preliminary injunctions that are technically still in place, protecting organizational members, members of FBC, SAF, and others, you have those preliminary injunction protections, but then also, like I mentioned, Judge O'Connor issued a final merits decision striking down the entire brace rule, and technically that is still in place, still in full force and effect, unless the ATF appeals, and they have 90 days to appeal and seek some sort of stay on that. But as of right now, if you're watching this, the pistol brace rule has no impact on you. Again, the ATF could do whatever they want. They go after individuals all the time. This is not legal advice, but that's how the things currently sit right now. So that's a quick update on what's going on with the ATF pistol brace rule. Again, if anything changes, if the ATF decides to do anything tricky, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.